Welcome, everyone. Welcome to the Sustainable Future Speaker Series at Cal Poly Humboldt. Since 2005, these interdisciplinary lectures have stimulated collaboration around issues related to energy, the environment, and society. All events are free and open to the public and are sponsored by the Schatz Energy Research Center, the Environment and Community Graduate Program, and the College of Arts, Humanities, and Social Sciences. Before proceeding, I wanted to acknowledge that Cal Poly Humboldt, where I'm located today, sits within the ancestral territory of the Wiyot people. There are 3 federally recognized Native American tribes in Wiyot ancestral territory, including the Bear River Band of the Ronerville Rancheria, the Blue Lake Rancheria, and the Wiyot tribe. And today I'd like to express appreciation for activities of the Hoopa Valley tribe, whose territory is to the east of where I sit today, in relation to energy and climate resilience, and just really interesting things that are being done there in relationship to that. The latest information about the speaker series plus registration for upcoming webinars can be found on our speaker series page, and we'll drop the URL in the chat. One other thing that I want to note in terms of upcoming events is that I'm happy to announce that the Schatz Energy Research Center will be holding a webinar titled Transmission Alternatives for California North Coast Offshore Wind. The webinar will be on Wednesday, May 25th from 1 to 3 p.m. Pacific time. And information will be forthcoming on the Schatz Center website, and we'll drop that link in the chat as well. If you have any technical difficulties during the session today, please post to the chat box and we'll try to help you resolve the issue. To turn on live captioning, please use the CC button in the bottom of your Zoom screen. Thank you to the caption team for joining us today and for providing that service. This evening's talk is being recorded and will be available online forthcoming at schatzcenter.org/speakers. Tonight's presentation will be followed by a Q&A discussion. If you'd like to ask a question, please use the Q&A box at the bottom of your screen. You can submit questions at any time during the session, and we'll hold them for the end for that discussion. Tonight's speaker is Andrea Rodgers, a senior litigation attorney at our Children's Trust, who will discuss children's fundamental rights, the climate crisis, and the call for judicial branch engagement. And my colleague, Dr. Jennifer Marlowe, will introduce our speaker for tonight. And so I'll pass it over to you, Jen.
Thank you so much, Arnie. And I should just say for the record that I'm not a doctor. I have a Juris Doctorate, but lawyers technically aren't allowed to use that title. So I should just make sure that I clarify that for everyone. But again, thank you, Arnie, and to the Schatz Center. Thank you so much, Andrea, for being here. I wanted to introduce Andrea, who's a very close colleague and friend of mine, to the Cal Poly Humboldt community. Andrea serves as the co-counsel on Juliana versus United States and as lead counsel on Aji P versus State of Washington and Reynolds versus State of Florida. Dubbed the climate trial of the century, Juliana versus United States advocates for the constitutional rights of children to a livable environment in the present and future. Andrea graduated from the University of California, Santa Barbara in 1998 and Arizona State University School of Law in 2001, where she served as the co-executive editor of Jurimetrics, the Journal of Law, Science, and Technology. Andrea then clerked for the Honorable John C. Gemmell on the Arizona Court of Appeals. She has also served as an honors attorney for the U.S. Department of Transportation, in-house legal counsel for the Snoqualmie Indian Tribe, and staff attorney for the Western Environmental Law Center. Her law practice has focused on reducing pollution from industrial agricultural operations, protecting and enhancing in-stream flows for people and fish, and fighting climate change for young people and future generations. Andrea, as I mentioned, is a close mentor of mine, a colleague, someone I'm honored to bring to our campus, if virtually. I'm so grateful that she's with us on Zoom. She also serves on the board of a nonprofit that I founded as a law student under the wise mentorship of her father, who was my law professor, Bill Rodgers, who introduced me not only to Andrea, but to all the other badass lawyers that I know. And just to say, Andrea is not only prestigious and prescient as a legal mind, but she's also a wonderful human being. She's smart, witty, surgical, and brutally honest. And so I'm just so honored to introduce her to the Cal Poly Humboldt community. Thanks so much, Andrea, for being with us.
Thank you so much, Jen. Thank you, Arnie, Kevin, Maya. It's such a joy to be with all of you tonight. I wish I was with you in person in your beautiful neck of the woods. But I'm joining you today from the shores of Puget Sound in Seattle, Washington. So I am on Duwamish lands, but I'm also, because I'm on the coast, I'm within the usual and accustomed fishing grounds of several tribes within the Pacific Northwest. So I'm at a crossroads, as it were, but I'm really excited to talk to you tonight about climate change. And I also, sometimes when you're talking about climate change, many of our presentations are depressing. The science is very difficult to hear, and I will share some of the science with you tonight. But, there's some good news happening with respect to what courts are doing with climate. The political branches, not so much, really have not been able to get this problem done. We really need the courts to engage, and that's starting to happen. So I'm going to share a little bit of that story, and I'll talk a little bit about our biggest case, Juliana versus United States, which is really the first time that climate change and human rights have been connected in a court of law. So I really look forward to joining you tonight, and let's get rolling. I'm an attorney and I work for an organization called Our Children's Trust, and we are a nonprofit law firm. It's a fairly unique kind of entity. We're not an advocacy organization like many nonprofits. We're exclusively a law firm, and we represent young people. We have a very narrow lane. We solely advocate for youth and future generations seeking their climate rights. We advocate for science-based and legally enforceable systemic remedies in court. And we take a fundamental human rights-based approach to the work that we do. We have cases in a number of different jurisdictions, both in the United States and all over the world. Here are some of the cases we have that are all in different phases. One thing you learn as a lawyer to be patient. The law works in very slow ways. You have jumps and starts and slowdowns and paths that you never thought would happen. And that's just how the law works. So here are some of the places where we're working in the United States. And this map is dated because we just have filed a case in Utah as well. We recently filed in Virginia, and Hawaii is coming up next. So there's a lot going on in climate cases, youth climate change cases in the US. I want to give a special shout out and to get all your calendars out, because in February of 2023, the first climate trial ever will happen in the state of Montana. And there, a group of 16 remarkable young people have sued their state government for pursuing energy policies that perpetuate the use of fossil fuels and harm them in extraordinary ways. And this is the first case that will go to trial. It will really be the first climate case to go to trial in the United States. So we have a tremendous group of experts who will be testifying. And the youth themselves will be testifying. So that will be an extraordinary moment. Please follow this development as it progresses. It will be a really exciting day for these young people to finally get their voices heard in a court of law. And Montana is a very interesting state, as you know, as the energy experts at Schatz will tell you. It's one of the biggest fossil fuels extractors and producers. Very interesting place to be doing this kind of litigation. So that's coming up in February of 2023. We also have the joy of working with young people around the world. I have to give a shout out. These are my clients from Canada, The case is called La Rose versus Her Majesty the Queen. So we get to sue the Queen. It's kind of cool. It's probably our best case name. We have a case against the federal government challenging their conduct in causing emissions. Very interesting things happening in Canada right now as well. So there'll be some new developments in that case in the coming months. But again, an extraordinary group of young people, many Indigenous First Nations youth as well, that are part of that case. We also have cases in Uganda and Pakistan and India and other and support climate change, youth and climate change cases around the world. I do want to talk a little bit about the science, and we just got to do it a little bit. And because the reason I want to do this is because it gets a little complicated with respect to presenting science in courts. And that's what I've always been fascinated with. And I came from a science background into the law. And I studied under Professor David Kay at Arizona State University, and he was really an expert in this area. And at that time, it was newly evolving, sort of how do courts consider and contemplate what science is admissible in evidence. And so we really need to go back to the roots of climate science, sort of what we really understood. And the concept that I want you to walk away with today is the concept of Earth energy imbalance. That's what's vital with respect to addressing climate change. And it's often not talked about a lot. But there's some wonderful science. It's really because they're able to measure this. So what Earth's energy imbalance is because of a buildup of carbon dioxide and other greenhouse gases in our atmosphere, because of burning of fossil fuels and other activities taken on by humans. We retain more solar energy is retained in our atmosphere and less energy is released back into space. And so that's what creates the imbalance. Humanity has evolved during a time when energy was in balance. So the energy balance was zero. So we were absorbing as much as we were giving off into space. And that's what's allowed our coastlines to remain stable. It's allowed ice, so that that affects the coastlines. And they're able to now measure what the energy imbalance is because of the heat that we're retaining. So while focusing on global average temperature increase, it's helpful, it misses the broader picture. It's sort of like you go to diagnose someone and all you look at is that they have a fever. You don't look at what's causing the fever. You just look at the fever and you measure, okay, the fever's 99, 100. That person is sick, but you're not looking at the cause. You really got to look at the cause. And that's what Earth's energy imbalance is. And my favorite analogy from my colleague Anders Carlson gave me, so it's like you took an ice cube out of the refrigerator and you put it on the counter, right? So the ice cube is going to melt, right? But so Earth's energy imbalance is the amount of heat. It's like if you put a blow dryer on the ice cube, that's where we are right now because we have so much excess energy in our system. We have a blow dryer on that ice cube, so it's going to melt really, really fast. So what do we need to do? We need to put that ice cube back into the freezer in order to preserve our ice. And the way we do that is by restoring Earth's energy imbalance, and that requires reducing carbon dioxide emissions to about 350 parts per million by the end of the century. So that number is very, very, very important. And getting there requires not only reducing our emissions, zeroing out our emissions, but it also requires significant amounts of carbon sequestration because we're so far beyond 350, right? We're about at almost 420. So we got to suck all of that out so that we can restore Earth's energy imbalance and retain our climate system that humanity really, really depends upon. And here, just, when you do climate work, you have to find joy in very odd things. And so one thing that gives us joy is we come up with analogies as to how much excess energy is in our system. We've had, Hiroshima bombs analogies, which none of us liked. There's been eating Twinkies, which some of us liked, but some of us didn't. But so for California, I thought I'd bring this to you. It's enough energy to bring 6,000 Lake Tahoes to a boil. This is a huge amount of energy, and most of it is being absorbed by our oceans. And that's why we've only warmed by about 1.1 degree, because our oceans have taken on so much of that heat. And while we can say thank you to our oceans, it really harms that our system, our climate system. Oceans play such a big role. So that's why getting down to 350 parts per million is so vital. And I want to distinguish this. You see a lot in the news, you hear from the Paris Agreement about keeping temperatures to 1.5 degrees warming. That will not stabilize Earth's energy imbalance. That will keep us out of balance. That's correlated to around like 400 to 420 parts per million. So if we limit warming to 1.5 degrees Celsius, that's catastrophic. That will continue many of the impacts that we're seeing. And, they're very clear about that, but people don't report that. And there's a very big disconnect with respect to what's reported and what governments are doing between what the scientists will say. If we were to ask a scientist, is 1.5 degree warming safe? Should we target that? Should that be the goal? And they say no. And the IPCC really agrees with that. They recognize that 1.5 degrees of warming is not considered safe for most nations. And I represent kids, and it's really not safe for them. It may be safe for those of us that are not on the planet long enough to experience the impacts associated with 1.5 degrees, but it's not safe for children who will be on the planet far longer than we will. And this is a really important miscommunication that's going on. We had climate denial for years and years. Climate change wasn't real. Climate change is a policy issue. That's the new denial talking point. But this is just as significant, because if this is where we're aiming all of our policies, we are just putting our children into an exceptionally dangerous position. And when judges or courts enact and enshrine these dangerous targets, it's really hard to get away from that. So I just want to give a few examples. Why should we not target 1.5 degrees warming? Well, just look at sea level rise. Sea level rise, if we limit our warming to 1.5 degrees, we're still out of energy imbalance. So we're still melting ice. Our seas are still rising. It may take longer, but we're still rising, and we're still having those kinds of catastrophic impacts. And this is the one that really, I don't know, it just hits me the most. And I saw this as a new study that came out this year. And it talked about how important for coral reefs, refugia is what's vital. So we're having all of these bleaching events around the world, but what's saving our corals is that they have time to recover. So the water temperatures will drop, they'll have time to recover, and this will show you, so it looks like, from present day, there's a lot of percentage of places where corals can recover. But when you get to 1.5 degree warming, you're looking at 100% no refugia. So it means it's reduced to 0.2%. So corals just don't survive. And they anticipate that at 1.5 degrees warming, we lose about 70 to 90% of our corals. That's a really, really big deal. Not because coral reefs are just beautiful places to visit. They feed billions and billions of people on this planet. And we're looking at hitting 1.5 degrees warming potentially in a decade. So that's not where we should be going. And so when we advocate on behalf of young people, it's important that the courts hear this science so they understand what the reality is. The Paris Agreement was helpful in that governments came together and agreed to reduce emissions, but that was a political compromise. That was not a debate among scientists. That was a debate among politicians. And as you know, politicians don't always make their judgments based on science. They make their judgment based on what they can get done given the political reality. Well, we argue that the political reality shouldn't define young people's fundamental constitutional rights. This is my favorite graphic of all for climate change. I just think it addresses so many of the questions that you hear. This is sea level rise, global temperature, and carbon dioxide emissions. You can see how closely correlated they are. It just makes sense, even if you're not coming from a science background or a math background, you could sort of see, okay, when you're looking at certain levels of carbon dioxide emissions, that really tells you what temperature you're going to get, and the sea levels follow closely behind. So, okay, here's where we are. You go to the far right there, we're up, around 416, 420. We are putting in carbon dioxide is increasing in the atmosphere 100 times faster than ever before on this planet. 425 million years ago, there were a lot of volcanic eruptions, and so you had a significant spike, but it's still faster. It's really incredible. We've never seen this happening before. So we have really increased so quickly, so you can expect temperatures to follow and sea level rise to follow. It's a complex system, so it takes time for us to see these impacts. But I think this is a really important slide to understand where we're going. And again, the importance of 350 parts per million, because that puts our Earth in energy imbalance, and that gives us our stable coastlines. So what do we do? Here's this tremendous systemic problem. What are we doing about it? What is our work about? So climate change doesn't just happen. Governments create energy policies, and it's really our energy policy and our energy systems that have caused this problem to begin with. So we take an approach that we focus on the governments who are creating these energy policies, and we challenge them. We challenge the affirmative misconduct that is shortening these children's lives and is harming our climate system. One thing that's an important legal distinction to make is our cases are not failure to act cases. We don't have a context of government just sitting there twiddling their thumbs, not doing anything. No. Governments are issuing permits. They're making our energy policy. Bush's energy policy was drill, baby, drill. Obama's energy policy was all of the above. Biden's, we aren't quite sure what his energy policy is. He says one thing, but we're seeing something different. So I'm not sure what his energy policy is. But throughout the generations of our presidents, they've all set our energy policy, and they dictate how we get energy. It's very controlled system. They permit oil refineries, they permit mines. This is all something that has government stamp of approval. So we are challenging that affirmative conduct of government. And our cases are very unique in that we're not challenging individual actions. So for example, a state can issue a permit for a coal mine or a gas plant. We don't challenge those individual actions. We're challenging the underlying system that's causing the harm. So our cases are inspired by and modeled after systemic civil rights cases, such as Brown versus Board of Education, where they were challenging the system of separate but equal. They didn't challenge one school, they were challenging that entire system of separate but equal. And that's what our cases are doing as well. And we take great inspiration from the work of those before us. And one thing Jen can tell you as lawyers, we're wonderful copycats, because precedent is a huge, important part of our work. So we really can take inspiration and apply it to different circumstances. So that's what we're doing with our litigation here. And why youth? Why do we represent young people? Well, they don't have political representation. They can't vote. They don't have money to lobby. And oftentimes young people are the ones who really are leading the charge with these systemic social issues. We saw that with integration in public schools. We're seeing that with Black Lives Matter. We're seeing that in the gay marriage movement. Young people are really standing up and speaking their minds, and going to the courts is one way that they do that. And we're really seeing that with respect to climate as well. So I do want to talk a little bit about Juliana versus United States. These are the 21 young people who are the plaintiffs in the case. They are from all over the United States. We have kids from Oregon, Florida, New York, Colorado, all over. They have so many different stories with respect to how they're being impacted. And they have joined together and they filed their case in 2015. So this is litigation that's been happening for almost 7 years. I told you, lawyers, we have to be patient. The kids have to be patient. Levi, who is right there, the purple pants and the turquoise jacket, he's been a plaintiff almost half his life. He's 14 now, and he was 7 when they filed the case. So these are kids who have literally grown up in the courtroom. So our case is a constitutional case. We have challenges arguing that the government has violated the young people's rights to liberty, security, equal protection of the law. And we also have public trust claims. We're arguing that the government has failed to protect essential public trust resources such as air, water, ocean, and shore. California has the strongest public trust doctrine, probably in the continental United States. We're arguing that the federal government similarly has a public trust obligation to protect our essential natural resources, and it's a sovereign aspect of our government. Here's one of our plaintiffs. This is Aji Piper. He lives in Seattle, Washington, where I am, and this photograph was actually taken pre-pandemic. This is because of the wildfires we get in our region now. This is often what our Augusts look like. And you in California, I'm preaching to the choir. I know what you have all lived through and are experiencing. And one of my clients in the Washington case says, it smells like summer. And that's hard to hear from kids because this used to be the most beautiful time in the Pacific Northwest. And I can't emphasize enough how much this affects their lives. You know, they have camps are canceled. They're being advised to stay inside. They can't go to school. They have to buy air filters for their home. They can't ride their bicycle. These are huge life changes. And Mary Robinson recognized in 2016 that it's really implicating these young people's rights, human rights, rights to life, rights to liberty, rights to their family autonomy, their cultural autonomy. And those are the kind of arguments that we are bringing in court. So we filed our case in 2015, and this was 2 days after President Trump was elected. We filed in the District of Oregon, and Judge Ann Aiken issued a beautiful, groundbreaking decision denying the government's motion to dismiss. So at the time we filed, it was the Obama administration was in charge, and they've moved to dismiss the case, arguing that we didn't have standing to sue. And the judge recognized for the first time that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. This is the first time any court made that kind of finding. It was a beautiful moment. And in a normal world, you would go to trial. And here's what she said. So just to let you know, in the United States, courts are very averse to the concept of a constitutional right to a clean and healthy environment. Some states have that enshrined in their constitution. Federal courts loathe that right, and I don't know why. They have this aversion to it. You should read the cases. They just, of course there's no right to a clean and healthy environment. Of course there's no right to this. Of course there's no right to that. The case law is really interesting, just the visceral reaction to federal courts. So she was very clear in that it's not a right to just a clean environment or to a right to no pollution. It's something far differently. It's when a complaint alleges governmental action is affirmatively and substantially damaging the climate system in a way that will cause human deaths, shorten human lifespans, result in widespread damage to property, threaten human food sources, and dramatically alter the planet's ecosystem. Okay, then you can raise a due process claim. That's a high factual burden, right? But unfortunately, we can meet that burden because of the damages that we're seeing. So it's a very narrow right that she established. Not anyone can establish it. This is a tremendous fact pattern that you would need to show in order to invoke this. So as I said, normally we would, after you deny, the motion to dismiss gets denied, you go to trial. Well, here's what happens in the United States in a climate change case. This is what happened to us. This would never happen in any other case. This just happens because it's climate change. And our courts are still grappling with decades of climate denial. They're grappling with the narrative that climate change is a political policy issue that, courts have no role in playing. So this is what happens to us. It's a very complicated procedural history. We should have been able to go to trial. Instead, what the Trump administration, who then came in as defendants, did, they filed what are called petitions for writ of mandamus. You rarely see these. These are what courts characterize an extraordinary remedy. You essentially file them when the district court has gone rogue. They're not applying the rule of law. They filed 6 in our case, which is the record. We've done public records requests, and no other case has had that many petitions for writ of mandamus filed in their case before. The second closest was 4, so we have them beat by quite a bit. And ultimately, we were set for trial on October 29th, 2018. We were ready to go. We had done 50 depositions in 60 days. We had our 21 experts lined up, ready to go. They deposed our children, asked them questions about what's the scientific equation for ocean acidification, which our children answered meticulously. And 10 days before trial, Chief Justice John Roberts issued a stay. He said, nope, let's get the Ninth Circuit. Let's have the Ninth Circuit. So we go up on what's called interlocutory appeal, which means an early appeal. In a normal non-climate change world, you don't get to appeal until after you have a trial. But this is climate change, so you get to go up early. There are some limited exceptions, but climate change is the big one. So here we are in the Ninth Circuit Court of Appeal. What's the issue? Is it that climate change isn't real? Is that these kids aren't being injured? What's the issue? Is there a case or controversy? Does the court even have the power to hear these cases? Can these kids get into the courtroom door? That's the question. It's not what we should do about the government's energy policy. It's not, what's the proper remedy. It's whether these kids can even get in the courthouse door. Can they protect their constitutional rights? Which, as a law student, we learn absolutely. Courts are designed to protect our individual constitutional rights. So that's what we argued in the Ninth Circuit Court of Appeals in 2019. Here's what we've won so far in this case. There's a lot that we've won. The courts have agreed with us at every turn. Judge Aiken agreed with us. We were before a magistrate before we were with Judge Aiken, agreed with us at every turn. Many of the Ninth Circuit judges, as we've gone up and down, have agreed with us. A lot of this is just not contested. Most importantly, that the children are being injured. Not only are the children being injured, it's the government that's causing the injuries. So the United States is responsible for 25% of cumulative emissions causing climate change. The United States is the big dog. You look at other countries that have surpassed the United States, but you look back in time and cumulative emissions is what matters with respect to Earth's energy imbalance, right? Because that's what's creating the energy imbalance. So United States, substantial cause of their injuries. So, okay, they're injuring us. Should we get a remedy? That's what this case ended up being all about. I want to take you through a little bit of the majority opinion because it's pretty remarkable what they say and what they recognize as being true. So substantial evidentiary record documents that the federal government has long promoted fossil fuel use despite knowing it can cause catastrophic climate change, and that failure to change existing policy may hasten an environmental apocalypse. Do you have standing to go to court to prevent an apocalypse? I hope so, right? How else are you going to do? How else are you going to deal with that? That's what they're calling this. Those are their words, not ours. Atmospheric carbon dioxide skyrocketed to levels not seen for almost 3 million years. These are all court findings. Unprecedented rise in CO2 emissions stems from fossil fuel combustions and will wreak havoc on the Earth's climate if unchecked. So this was in the record from declarations of our experts, and it was uncontested by the federal government. The extreme heat is melting polar ice caps and may cause sea levels to rise 15 to 30 feet by 2100. I hope those of you in coastal areas look at this and it spurs you to action, because that's incredible, incredible. That would absolutely change Earth forever. Impact millions and billions of people if that's the level of sea level rise that we experience. And most importantly, they looked at the harm to the young people And it was individualized particular harm. They were experiencing damage to their property. One of our clients, Jaden, her home was flooded in Louisiana in a place that had never been flooded ever before. Psychological harm, they recognized the gravity of that. And again, these photographs, these are pre-pandemic. These are children in Oregon in wildfire smoke. This is our plaintiff, Jamie, who's Navajo. She had to move off of her family property on the reservation because their springs dried up. They couldn't water and feed their animals. They couldn't grow their crops. And having to leave and evacuate her cultural home, her family, is extremely distressing. Those are injuries that the court has recognized are happening, and they rise to the level of cultural or constitutional injuries. The court recognized the country's now expanding oil and gas extraction 4 times faster than any other nation, and President Biden still has his foot on the gas. This hasn't come up. The dissent characterized it as an existential threat actively backed by the government. And here I just want to talk a little bit about a big part of our evidence is the long-standing knowledge of the United States of the danger. And the reason for that is because we have what's called a state-created danger claim. In order to bring a claim that the government has violated your right to life or liberty, they don't have an affirmative obligation to protect your life, but they have an obligation to protect you if they're the ones who cause the harm. So you often see this in cases. So for example, a police officer arrests an inebriated person, and instead of bringing that inebriated person home, they put him on the side of a freeway, and the person wanders into the freeway and then is hit by a car and dies. Well, the estate can bring a lawsuit because it was the officer who placed that person in a position of danger, and then they had constitutional rights deprived. So that's what we are arguing about the federal government. And here's just a few examples. Our expert's name is Gus Speth, and he was in the CEQ with President Carter, so the first CEQ. And his expert report has actually been published in a book called They Knew. And he goes through all of the different administrations and all of the warnings and scientific documents that they received. It was really clear that that climate change was happening. The science is very simple. They knew what was going to happen. They knew they needed to get off fossil fuels, but in spite of that knowledge, they continued on this course towards destruction. Here's from 1970. This is for John Ehrlichman, and we have no data in Seattle. He was a Seattle guy, so that's why they have that in there. And here, it's not a political question. The Republicans and the Democrats have been similar in terms of their energy policy, whether they call it drill baby drill or all of the above. Fossil fuels is always their foremost priority. And that's why we are on the path that we are. We have not yet had an administration that has committed to getting off of fossil fuels, and not just in rhetoric, but actually affirmatively implementing policies that get us off of fossil fuels. And this slide is 2 years old, and I hate to say, are we going to have to erase the arrow that goes on the downward trajectory? If we had to do that now, that would go away because we're still going up, and the political policies haven't been implemented. So the majority said the problem is approaching the point of no return. Absent some action, the destabilizing climate will bury cities, spawn life-threatening natural disasters, and jeopardize critical food and water supplies. These are facts that they accepted as true. These are true. These are not disputed facts. The government did not dispute these facts. They had no evidence to contest these. So when that's happening, these facts are true. What is the role of courts? Do they have a role to step in and do something when these children, American children, are being harmed by their own government? So the majority agrees this is what the case boiled down to. The case boiled down to the majority's conclusion that even when government causes the injury, the constitutional injury to young people, there's nothing an Article 3 court can do about it. That's what the holding was. They said we don't have redressability, which is the third element of standing. Fortunately, there was a beautiful dissent. This is Judge Staten from beautiful state of California, Central District of California. She was sitting on the panel by designation, and she dissented. And her dissent, I think, will go down in history as the right way, the right side of the law, like we've seen in other cases. And I'll take you through some of how she viewed this. You know, she didn't just view this as an issue of government harming children. She viewed this as government destroying the entire nation and our foundations of democracy. If the government takes action that actually harms the nation itself, there should be some check and balance on that authority. That's how she viewed the issue. And what the majority said, oh, no. These kids, they can solve their problems at the ballot box. Do you know how awful it is to tell my 14-year-old client that their remedy is to go vote? He can't vote. He has no political power, which is why courts are supposed to protect minorities like young people, because they don't have the political power that others have. But that's not what the majority said. The majority said, oh, and this would be too complex for us to enjoin the government's energy system. So they reject what's called injunctive relief. We had asked that they order the government to prepare a climate recovery plan. Just figure out how you're going to solve this problem and how you're going to reform our energy system. We didn't ask the court to tell them how to do that. Courts don't do that. But they can tell government to fix systems. They've done that with prisons, schools, mental health facilities, foster care systems. There's many, many examples of courts saying and intervening when there's systems that are unconstitutional. But here, the majority rejected that. And I was reading, Thurgood Marshall has some beautiful oral arguments in some of his school desegregation cases. And this was in Briggs versus Elliott. And what he said was the US Supreme Court has said that insofar as segregation is a tough problem, it was tough, but the solution was not to deprive people of their constitutional rights, right? When an issue is complex, you don't just err on the side of infringing constitutional rights, you err on the side of fixing the constitutional violation. That's what Thurgood Marshall said. That's what the majority should have done, but they did not do. You know, and what the dissent said about that was fundamental rights may not be submitted to vote. They depend on the outcome of no elections. They are beyond the reach of majorities and officials. This is a common canon of constitutional law. You know, fundamental rights cannot be put to vote. That's what, you know, that's not how our system works. That would be giving your constitutional rights to the majority, and that's not why we have the system in place. And again, you know, looking to Thurgood Marshall, whether or not I, as an individual, am being deprived of my right is not legislative, but judicial. And he's right. Otherwise, you know, you could legislate away, you know, all sorts of constitutional rights. And we're seeing that these days in places like the state of Florida and other places. And that's when courts need to come in and check that legislative exercise of authority. That's what we were asking the court to do, but they didn't do it in this case. So when it comes to remedies, you know, courts are very familiar with constitutional remedies. You know, what they're first supposed to do is they're supposed to declare whether or not the government conduct is constitutional or unconstitutional. That's the first step. And then sort of how you fix the problem, all of the complexities, that's the second step. But that declaration of law is so vital. And so that's really what we're focused on getting. And the court just glossed over that. They just didn't even address our request for declaratory relief. They focused exclusively on our request for injunctive relief and the remedial plan. So the Juliana dissent concludes, when the seas envelop our coastal cities, fires and droughts haunt our interiors, and storms ravage everything in between, those remaining will ask, why did so many do so little? And that's such an important, powerful question I think all of us ask ourselves, and we should be asking ourselves today when we look at the future that our children are facing. You know, what can we do? How can we facilitate this change, this systemic change that needs to happen? What role do we all play? And more importantly, what role do the courts play? And what role does government play in facilitating that change? So next steps. So what the court did is they dismissed our case, but they dismissed it without prejudice. So that means we should be able to come back and amend our complaint to fix whatever the court thought was wrong. So we've done just that, and we filed a motion to amend our complaint. We took out all of our requests for an injunctive relief and the climate recovery plan. We said, okay, the court was not comfortable ordering that. Now just give us a declaration whether or not the United States energy system is unconstitutional. That's the first step. So we've pared back our complaint. We've asked Judge Aiken to rule on that. She could rule on that any day. We are waiting for that. And if she grants our motion, we will be back on a track to trial. And the only question will be what the Biden administration's DOJ is going to do. Are they going to file their 7th petition for writ of mandamus? Or are they going to let these kids go to trial? You know, letting these kids go to trial does not mean you give up. It does not mean you lose. It means these young people are able to testify in court and have their experts testify in open court, which is such an important part of the process. So stay tuned. We will hear and see which way this develops in the coming weeks and months. So, you know, how do we maintain our hope? You know, these kids have been fighting that battle for almost 7 years. You know, what gives them hope? How do they keep on moving forward? How do we all keep on moving forward? And, you know, as a lawyer, you know, dissenting opinions are very important because that's really how the law evolves and changes. And that's what we're starting to see. When we first started doing this work a decade ago, courts were like, oh, climate change, we can't handle that. We never got a dissenting opinion. It was an easy dismissal. No way this is going to happen. Now we are getting dissenting opinions, and many of these youth climate cases are winning. Places like Germany, Belgium, Netherlands, you're really starting to see a change in terms of how the courts are viewing their authority with respect to climate change. We're really at this precipice of exciting developments in the law. And, you know, to be honest with you, the United States will be the last to get there. Other courts will get there before the United States, but we are the most important. We are the biggest emitter. We're the biggest bully dog in the room when it comes to international climate policy. So we have to get US courts going in this direction. And we're starting to make that turn. It's slow, and hopefully we can get there in time. But there's examples of when dissenting opinions really turned and carried the day, whether it's Plessy versus Ferguson and Son Brown versus Board of Education went the other way. Korematsu versus United States. There was a dissent. Justice Jackson in that case said, you know, this is not right. We're violating Japanese Americans' constitutional rights by interning them. And ultimately that won the day. I think we're starting to get on that pathway. And here's why. You know, here's what some of the justices are saying in some of our state cases. As I mentioned, you know, there's great wins in other countries, but we're starting to get good wins in state courts as well. You know, courts also must not shrink from their obligation to enforce the rights of all persons to use and enjoy our invaluable public trust resources. So, you know, here are judges and chief justices at that saying, you know, we need to engage. You know, courts aren't going to solve it on their own, but there's a role for the third branch of government in fixing these problematic systems. The same thing in the state of Washington. Chief Justice Gonzalez and Associate Justice Helen Whitener. Declaration of Rights is meaningful relief. That's what we're asking for now in Juliana. Even if it's not a magic wand that will eliminate climate change. They understand that they're part of the process. They need to put that pressure on in order to help that systemic change, enforce that systemic change, and hold the legislatures accountable. And also in Alaska, we're seeing these dissenting opinions. In Alaska, we lost the case 3-2, but 2 of the 3 majority opinion judges were no longer on the court. They were already retired. We were kind of like, well, can't we just say we won 2-1? That's not how it works. Retired judges in Alaska, they still get to have their say, I guess. But, you know, very powerful dissent recognizing the constitutional right to a livable climate. Hawaii's Supreme Court has just recognized the right to a livable climate is part of their right to a clean and healthy environment. So we're really starting to see the tide turning with these opinions, which I think will be pivotal and has the potential to really push things in the direction that needs to go. I do want to give a mention to our work in Florida, because Florida is a really hard place to be in for young people these days. I don't know if you're following the politics. Not just are they attacking Walt Disney, but they're, attacking children's ability to seek care and treatment for their mental health ailments, whether they can mask themselves in school. There's been a big attack on children, and it's just a very difficult place politically, but we just had a big victory in Florida. A group of young people, over 200 young people with 4 lead petitioners, asked the Department of Agriculture and Consumer Services to promulgate a rule setting a goal of 100% renewable energy by 2050. And it was based on a energy pathways study conducted by Evolved Energy Research, which looked at how do you decarbonize the Florida energy system. And so the percentages for the different years came directly out of that study, and they granted that petition for rulemaking and issued the proposed rule on April 21st. We're hopeful that that will continue to go forward and be finalized in the coming months. So, again, these are not all the be all end all, but these are important pieces of the puzzle that we're starting to see happen. I mentioned earlier, here are just some of the cases that we either support or have been inspired by Juliana around the world. Many are seeing significant success in their courts. The US will be the last. We're confident in that, but we're really seeing some movement, which is wonderful. And many of these cases, all of these cases here, are led by young people. It's young people who are standing up and taking their governments to court because they don't have the political power, and they're exerting their power and their influence in terms of protecting their constitutional and fundamental rights in that way. One thing I really want to announce we're really excited about, and I think there'll be a link in the chat, but there's a beautiful film that was done on the Juliana case. A filmmaker did a wonderful job following the kids from the very beginning, and she created an independent film, not something that we did, but it was her own making of the kids and their journey through this process. And it's premiering on Netflix tomorrow. So please, if you have an opportunity, watch it. It's wonderful. You'll learn a lot more about the litigation, as well as the young people who are bringing the case and what they've gone through as plaintiffs. It's not easy to lead the charge in something like this. So that will be on Netflix starting tomorrow, and watch it this weekend. It has something to do with algorithms, is really important, but I'm not quite sure how that all works, but it's a really exciting moment that people will be able to see and learn more about these young people. So that's where I'll end it today. I look forward to the discussion with Jen and any questions that anybody has. I'm always available if you have any specific questions and want to email me independently, any questions. I will say one of the things that we're working on is an action in the state of California. I can't share much more about it, but if you know young people who would be interested in doing this kind of advocacy work, please have them get in touch with us, and we can see if it would be an opportunity that they'd be interested in doing. So thank you so much for inviting me here today, and I look forward to our discussion.
Andrea, thank you so much. It's so wonderful to hear such a history, and going back to Plessy v. Ferguson and understanding the legal system. You've talked a lot about the energy system, but it's really, I think, helpful for our audience to really profile this legal system that you're trying to find communication that's trying to communicate the dangers to our constitutional rights from our energy system. So I think it's a wonderful introduction to the complexity of the challenges that our young people face, but you've done such a great job to clarify. Sorry, Jojo, this is my daughter, Joan, everybody.
Hi, Jojo. So in one of my first arguments in the Washington climate change case, I had my daughter, Vivi. Her dad had her in the back of the courtroom, and she was a 6-month-old baby, and she kept on saying, hi. And so the judge actually asked her to leave. So I can honestly say my daughter has been kicked out of court.
Well, hopefully we won't kick Jojo out of the SHOTS webinar.
No way.
No way. Let me ask, I have a couple of my own questions, but I'd like to start with questions from the audience. The first one is, from Maya at the Schott Center, from a legal standpoint, what do you think we need to understand about the intersection of youth, migration, and climate change?
Jen, I'm so sorry, you cut out a little bit. Oh, I see it in the chat. I can look in the chat too.
Well, maybe I'll repeat the question just for the audience too.
I got it in the chat. It's about the intersections of youth, immigration, and climate change. Oh, that's such a good question, because there's a lot of different intersections there with respect to the law. The immigration, there's been a lot of immigration cases recently at the Supreme Court. And so legally, the government has control over our immigration system as well. So there's a lot of analogies there, particularly during the Trump administration with respect to what they were doing with immigration. And so a lot of the cases were sort of following a similar track, and were also decided on the shadow docket that we were on. That's what Chief Justice Roberts decided to stay us. That was on the shadow docket, which is the Supreme Court will issue certain decisions not based on full briefing of the case, but sort of at a really early preliminary stage, and it's been coined the shadow docket. So there's some sort of more, legal questions, but with respect to other, from a factual standpoint as opposed to a legal standpoint, I mean, that's a huge issue, because we're talking about the loss of certain communities and places, and people will be having to travel and leave and be displaced. So the youth are very, familiar and very much, I've seen a very fear of that issue, particularly the young people that I work with in Florida, because they're seeing displacements now. Places like Little Haiti, which are high elevation, are being displaced. And these are, oftentimes immigrant communities who've established, their own community there. So I don't know if that's what you were looking for, but there's tremendous, there's a lot of there's factual connections, and I think there's a lot of legal intersections there as well.
Thanks, Andrea. Another question from the audience from Danica Z. Do you think that local government ought bar new residential and commercial development in coastal communities?
Oh, that's a hard question. And I'll caveat this with, I'm a lawyer, so I could never get into these policy issues with the court. The court will never get into these granularities. So I will say that. However, I do know, you could go to Miami and you can buy a piece of coastal property and get a 30-year mortgage, and no one would tell you that it's not going to exist within 20 years. I mean, it's really incredible. And, so there's so many levels to that issue, because, people don't understand the perils of what you're facing. And I just had breakfast with our sea level rise expert, Dr. Harold Wanless, who's at the University of Miami. Sadly, his nickname is Dr. Doom, because he understands how sea levels have risen in the past. He doesn't look at the models. He hates the models. He's like, too much uncertainty. They don't take into account ice melt. He's sort of a curmudgeon. He's one of my favorite experts to work with. But he has seen, because he knows coral reefs and how you could figure out sea levels have risen in pulses, really quick pulses, and then they level off. They don't rise linearly. And so sea level rise is happening much faster than than the models had ever predicted. I mean, you look at what's happening in Antarctica right now. I mean, it's really, really incredible. So we're really on the precipice of things moving much more quickly. The studies are showing that the permafrost in Scandinavia has already reached a tipping point. So that means we're not going back there. That's beyond the point of repair. So when you start reaching those tipping points, these systems really will start to move much more quickly, I think, than anyone imagined. So yes, I think there's important need for communities to be doing those kinds of adaptation and thoughtful planning. It's so expensive Some of my plaintiffs live in a community called Tahola on the Washington coast. They're Quinault. It's the Quinault's lower village, and it's right on the coast. It's almost like below the coastline. It's right on where the Quinault River is, and it's very low, and that's where all of their government services is. All of their elders live literally right there on the beach, and it gets flooded and inundated every year. And so they're looking to relocate, and they've actually found a village site to relocate to, but the costs are incredible. It's incredibly prohibitive. And so if you don't start planning for that now, I don't see how that happens in the future. So thinking about restricting new development, it's restricting new development. It's advising people who are purchasing homes, that they're aware of what's going on. What are the sea level rise projections in those areas? Do real estate agents have an obligation to inform and warn? Probably. Nobody. How about insurance companies? Insurance companies all of a sudden can just pull out, and you're seeing that in California, right? In communities that are subject to wildfires. So when do the insurance companies pull out of coastal communities and just say, sorry? So without that kind of planning and deep forethought, the citizens suffer. So that's why, when we work with government, we're talking about long range energy planning and adaptation and mitigation. You need to be thinking about this now. And unfortunately, most governments are not.
Thanks, Andrea. I'm going to drop my video because it sounds like my audio quality wasn't very high. Can you hear me okay now?
Yes, Jen, now you're crystal clear.
Okay, great. So another question that I would like to ask you is going back to Earth's energy imbalance. And you mentioned that when, part of your scientific expert testimony has told you, the lawyers representing these youth, that bringing Earth's energy back into balance requires reducing carbon dioxide to 350 parts per million by the end of the century. Is that accurate?
Yep, that's accurate.
Okay.
And it will probably, and after the 21st, after you get to 2100 Jen, it will need to be lower, because the ice experts say that you need to be around 270, 280 in order to preserve ice. So when you're at 350, you're passing that and continuing to go down when you're at 2100.
And so in light of that, what other thresholds have your scientists shared with you for other greenhouse gases, including methane? What threshold or limits do courts or others need to place on, say, methane to stabilize Earth's energy imbalance? How do you factor in other?
I have never seen or never heard an expert do that with methane. They really consider carbon dioxide because it's the primary driver. That's what's really important with respect to energy imbalance. And methane is much shorter lived. So I have not seen science that says, we need to cap methane to a certain number. It's reduced methane, of course, but I have never seen a scientific prescription like I've seen for carbon dioxide. And that makes the prescription itself makes it really useful, because in court, we need to provide the court with a judicially manageable standard. And scientists have done that for carbon dioxide, and I'm not aware of that being done for methane. I could be wrong and it could be out there, but I have never seen that in our work with our experts.
Okay, thank you. Another question is thoughts for students in the audience here tonight, or who will watch the webinar at a future date. Thoughts or advice for students who might be interested in pursuing, say, climate and environmental law at this time in their lives?
Sure. Yeah, I will say, so even if you don't want to do environmental law, you will be doing climate in your life. Whether you're a banker, you're in the insurance industry, you're an economist, you're going to be doing climate. If you're working in energy, education, you will be working in climate. So I think having a really solid understanding of the science is really important, so that you can see through sort of the talking points. And when someone says, oh, we're targeting our policies to 1.5 degrees warming, we should celebrate. No, you shouldn't celebrate. You can question that. So I just think it's important for them to understand that they will be working in climate regardless of what your career intentions are. And I think that's just, I really think that's the reality. And one of the things that we've been very fortunate with is surrounding ourselves with really good experts. I mean, Jen, you and I have talked about this, how pivotal that's been in our career when you meet people who really understand their areas of expertise. But very early on, we worked with Jim Hansen, and, nobody knows planetary science like Jim Hansen. I mean, he really knows planetary science and the physical principles about how this is happening. And so spending time with those people who have those expertise is really important. One of our coral experts is Dr. Ove Hugh Gouldberg, and he's from University of Queensland in Australia. And you just spend time with people like that, or Dr. Lisa Van Susteren, who's an expert on climate anxiety and youth climate change mental health harms. I mean, it really gives you a whole new perspective with respect to the work. And I will say, with the Schatz Institute, spending time with energy experts is the positive and exciting thing to do, because it's a technology problem. They're engineers, you can fix this. This isn't, it's so much more optimistic. I love spending time with our energy experts because it's a problem that they can solve. Here's how you do the transition. Here's how you decarbonize. It just, there's so much optimism and hope with the energy experts as opposed to the other climate science experts. So I would really focus on energy. I mean, that's where so much is going to happen. I mean, decarbonizing our energy system, I mean, that's on every level. That's buildings, that's transportation. I think having a good understanding of energy and how those systems work is vital for any student who's, as they're going through their careers, because that's where the jobs are going to be. That's where the action's going to be is really going to be in decarbonizing the energy system.
Thanks, Andrea. Another question from Arnie is asking you to comment on the linkages between legal approaches to establishing climate remedies in court and other strategies to address climate change through political processes like environmental justice activism. And what are the interrelationships between the two different strategies that you see?
Yeah, definitely. It's really all hands on deck. And, I just read a fabulous book by Richard Rothstein called The Color of Law. And I recommend that to everybody. And he wrote about housing segregation in housing, and how government really created integration in certain neighborhoods, and that whole history of that. And why I go back to that is because it really was a good story of not just, the political activism that was going on, but there was moments when the courts stepped in as the backstop. So they would find restrictive covenants, racist covenants that said you couldn't sell to a person of color. They would find that unconstitutional. And then local governments, well, what can we do now? Oh, we can discriminate using the tax code. So then that would be the next thing. And then the court would come in and say, no, you can't use race as a basis for discriminating with the tax code. And so the court would step in. And then there's all this activism going on in the background that's leading to those moments up in the court. So they're very intimately connected. And there's many examples of activism and the courts being connected in that way. Gay marriage is a really good example of that. There's so many protests, there were different actions going on, and it led to Obergefell, which, wasn't the be all end all, but it was an important moment as part of that, and really linked closely with the activism. And all of the young plaintiffs we work with, they very much consider themselves to be climate activists. And they often struggle. Why am I sitting in a courtroom when I should be sitting on a pipeline construction site? They really struggle with that conundrum, because they really question the system in and of itself. You know, young people really, I think, have the ability to step back and say, you know, should we really be participating in this system? But I think they see the value of all hands on deck, and they see the value of having hundreds of protesters out in the street, while at the same time there's people in the courtroom, while at the same time there's lobbyists in the halls of Congress, you know, while at the same time there's media campaigns going on. I mean, we need all hands on deck, and so we are a small part of that in the courts, and we collaborate very closely with respect to messaging and, you know, trying to make sure that when we need, because we are going to the Supreme Court. This Juliana is going to the Supreme Court someday, hopefully with a trial record, but it's going to the Supreme Court. So we need to be prepared for that. We need to be prepared for that. We're going to a Supreme Court where some of the Supreme Court justices think that climate change is about ozone. You know, we have a lot of education to do. You know, we have a lot of education to do before we get there. And, you know, so that's a huge part of the work that we do. And I think you'll see that if you see the Youth VGov campaign. You know, I think you can see in the film, you can see sort of how these kids came to this place in their advocacy.
Thanks, Andrea. A question from Kia Lowe from the audience. Do you believe we'll hit the 350 parts per million threshold in 2100?
I believe we can. So we have experts that have, again, our beloved energy experts, have said that it's technically and economically feasible for us to do that, to decarbonize the US energy system in line with a 350 parts per million trajectory by 2100. And they've said, here's what needs to be done in the 2020s. Here's what needs to be done in the 2030s. Here's what needs to be done in the 2050s. So it's, you know, I listen to the experts, you know, but I'm not denying our political reality. You know, we have a lot of work to do and the clock is ticking. So these next few years, you know, 2020 to 2030, this is the most important time. We have to build in place, and California is going through this right now. You know, how are we decarbonizing our system? You know, like the next webinar on offshore wind. You know, how do you connect that to the grid? They're dealing with all of those questions that need to be addressed. We work in Hawaii. You know, and they're about like 10 years ahead in terms of decarbonization of many places, you know, so they're really thinking about that and dealing with issues like siting. So I'm confident that we can do it, you know, because the experts tell me it's feasible, it's possible. So I put faith in them, but, you know, our political situation is very, very difficult. It's very difficult. We're dealing with very difficult politicians. And unless we have some political change, it's going to be really hard to get there. I mean, you know, in Montana, they deny that climate change is real. That was their answer. They denied that climate change was man-made. That was in their answer. So, you know, we got a lot of ways to go in many places. You know, these are scientific principles that have been documented for 100 years, and they don't think that's real. So, you know, we still have a lot of places to go. But then you look at places like my state, Washington, you look at what's happening in California, look what's happening in Hawaii in terms of decarbonizing our energy systems. It's really, really exciting, and things are really moving. But, you know, it needs to happen faster, and we need to get it to happen in Washington, D.C.
Hear, hear. A question also from Kia in the audience about our Children's Trust. How does our Children's Trust find the youth plaintiffs? Do you reach out to them and invite them into your campaign, or do they find you, or both? And also, where do you get your funding?
Yeah, so a little bit of both. You know, many of the kids find us. You know, my favorite story, so in Florida, I represent a young woman named Delaney Reynolds. And when she was 16 years old, she wrote the first solar ordinance in the state of Florida that was adopted by the city of South Miami. And it required all new buildings to have solar power when they're constructed. And she wrote that with the mayor when she was 16 years old. And she did that, and then she was like, you know, and then Governor Scott came in, and he was, you know, told his staff not to say climate change. And all sorts of stuff. And so she found us and said, what can we do next? You know, what are we going to do? This is not acceptable. Things are not happening. And she's a marine science student. She swims with sharks and from the Keys, so very familiar with what's happening with her reefs. So that's one example of young people. And the other example, you know, we let people know that there's opportunities, you know, to get involved. And, you know, like in California, if there's young people, you know, we have opportunities that are coming out. And so then kids will get connected. We have a lot of wonderful partners who connect us with young people. A lot of teachers follow the work that we do. We connect with kids that way. I will say today, kids are so connected. So most of the work is done by kids connecting with each other. They're much more effective at connecting with each other than we are, you know, through Snapchat and the ways that they do that. So that's really how we connect with young people. Another good story is Virginia. We just filed a case in Virginia, and that was because a group of 5 kids came to us and said, we want to sue our government. And it took us about 5 years to figure out the strategy, and they were patient. They hung out. They waited for us. And, you know, we ended up representing them in the case that was just filed. So it's pretty incredible what the kids are doing. We are a nonprofit, so we function based off of individual donations and grants from institutions and foundations.
Thanks, Andrea. And thinking forward to the day when Juliana v. US ends up in the US Supreme Court, I'm wondering about that map you showed of the international cases that have been inspired by Juliana. Do you think that these international decisions will find their way into our justices' legal reasoning as some kind of interpretive guidance for how to decide the claims of US youth? Do you think the international decisions will in any way influence our system here in the US?
I don't. I'm sorry, but our United States, our courts are very closed off and very little respect for what jurisprudence in other countries is where that's going. It was really Justice Scalia who said, you know, in the 8th Amendment, cruel and unusual punishment, the death penalty cases, Scalia said, I'm not interested in what other countries are doing. And the majority of our Supreme Court are Scalia disciples, and so don't see what's happening in other courts as very influential. But our Constitution says in black letter law, you protect the rights of life. And that's what's being threatened here. So they believe in black letter law, you know, the originalists on the court. So we have a good chance. Our cases are, it's actually a conservative case because it's grounded in, you know, you're taking away these children's fundamental freedoms, their ability to live. So, you know, it's a different perspective that we're taking in the Supreme Court, but I don't see, unfortunately, that having much influence at the Supreme Court. I think some of the other courts in this country will look, and other judges will look to other courts in other jurisdictions and be inspired by that. But I think that's my honest answer with the current makeup of the Supreme Court. You know, they really don't look to other countries' jurisprudence favorably, which is unfortunate.
And maybe just as a follow-up to that, and then I think we'll end with a final question, but a follow-up to that, speaking of black letter law, do you think that your Montana case will be in any way influenced by the fact that Montana's Constitution has an inalienable right to a clean and healthful environment? How are you using that
Absolutely
in your legal strategy? Is that helpful?
That's the centerpiece of our case. And that's, you know, what Republicans and Democrats believe in Montana is that they want to protect their natural resources. So that's what our case is really all about in Montana.
Well, we'll have to keep attentive to these really exciting developments. Andrea, what's the best way for people in the audience, or young people in particular, to keep abreast of all the really exciting work that you're doing at Our Children's Trust?
Yeah, our website has, all of that information. And for people who are interested in getting involved, whether volunteering or becoming a plaintiff, there's places for that on our website. And watch the Youth v. Gov film this weekend. Get some popcorn. There's a lot of hope in the film. It's a beautiful film. So please watch that this weekend. So that's the best way. And also, if there's other questions, like specific questions about our litigation or any of our expert work or any of the science I talked about, please email me. I'm happy to connect with you about that. Just be patient with me because I can be slow when things get busy, but please don't hesitate to reach out to me individually.
Thank you so much, Andrea and Jen. And thanks so much to the audience for participating tonight. I think we can wrap up for this evening, but really a fantastic talk and really interesting discussion afterwards. So a big thank you all around. A reminder again that we are planning to do our next event will be the webinar on transmission alternatives for offshore wind here on the North Coast. That's on May 25th from 1 to 3 p.m. And to learn more about upcoming events, please visit our website, which will be posted in the chat. And with that, thank you very much.